pre-action protocol for debt claims, or the debt protocol, just as we'll call it, has been in force since the 1st of October 2017. So 5 years now almost. Subject to certain exceptions, and this is really important, the debt protocol applies to any business, including sole traders and public bodies, claiming payment of a debt from an individual, including a sole trader, okay? The debt protocol, as we're going to look at today, does not apply to business debts unless the debtor is a sole trader, okay? So the debt recovery protocol only applies where a business is seeking payment of a debt from an individual, okay? Debtor seeking debt advice. So where the debtor indicates that legal advice is being sought, the creditor must allow the debtor a reasonable period for that advice to be obtained. Although a reasonable period is not defined as such, the creditor should not commence court proceedings until the latter of either 30 days from the receipt of the reply form or 30 days from the creditor providing any documents requested by the debtor. Okay, so that's quite a chunk of time, and this is something you need to make your client aware of, because I get cross clients wondering why things aren't moving quicker. So if a debtor comes back to you with the reply form, and in that reply form says, I'm seeking debt advice, you should allow about 30 days for them to do that. Again, and a reason why to make sure you provide them with everything in the first instance, if they come back requesting you for further documents, you should allow another 30 days once you've sent those. So where the debtor has responded to the letter of claim but no agreement has been reached, the creditor should give the debtor at least 14 days notice of their intention to start proceedings, unless there are exceptional circumstances in which proceedings are required to be issued urgently. So for example, if your limitation period is about to expire. So they've responded to your letter of claim, you've had some negotiations, you can't reach agreement. Really, you should give them at least 14 days notice of your intention to commence formal proceedings. Again, it might just give them that little nudge. Okay, they're actually going to issue proceedings now. We can put a bit more money on the table, that sort of thing. But do give them that notice as required.